law, which subjects all persons to the law. Secondly, Principle 17 of the Draft Principles on Military Tribunals is emphatic on the right of appeal from courts-martial, which by extension would include field courts-martial. Accordingly, the right of appeal from the decision of a field court-martial does provide a vital safeguard to the exigencies of their judicial processes. Its relegation to creation by subsidiary legislation is a misnomer that ought to be revisited. In the event, I would abide the proposition in Principle 8 of the Draft Principles on Military Tribunals that the circumstances under which field courts-martial operate do provide sufficient justification for their jurisdiction to try civil offenses, including capital offenses. Having so held, and considering that the General Court-Martial sits in appeal over decisions of field courts-martial, I would refrain from excluding civil capital offenses from its jurisdiction. I now turn to the constitutionality of Section 1171G and H of the UPDF Act. The controversy as to the constitutionality of those statutory provisions has arisen in numerous cases with varying results. It now falls to this court, under the present appeal, to pronounce itself with finality on the matter. The fundamental question is whether the parameters that are encapsulated in Section 117, 1G and H amount to exceptional circumstances that would justify the trial of civilians in military courts. The law is a major component of public policy and would thus be vital public policy consideration for the justification of the trial of civilians in military courts. Indeed, I am alive to the duty placed upon Ugandan citizens under Objective 29 and Article 3(4) of the Constitution to uphold and defend the Constitution and the law. This perhaps explains why criminal law considers a person that aids or abets the commission of a crime or has a common intention with others in the commission of a crime is criminally culpable. Reading Section 1171G of the UPDF Act, together with Section 191C of the Penal Code Act, would suggest that a person that aids or abets a serving or active military person in the commission of the service offenses delineated in Part 6 of the Act would be deemed to have taken part in committing the offense, be guilty of the offense if proved, and may be charged with actually committing it. In practical terms, Ayume Francis in Criminal Procedure and Law in Uganda posits that a person who aids and abets another in the commission of a crime may be joined in one charge sheet and tried together with those who actually commit the crime, but the particulars of the offense must clearly indicate the role of the aider and abetter. I take the view, therefore, that criminal culpability by way of aiding and abetting the commission of a service offense is sufficient justification for the subjection of a civilian to military law. I respectfully do not abide the view that such trials should not axiomatically ensue in the civilian courts. In my view, the fact that the principal offender is a person in active military service and charged with a purely service offense warrants the recourse to military courts as opposed to civil courts for the trial of both the principal offenders and their accomplices. Furthermore, the intricate nature of service offenses encapsulated in Part 6 of the UPDF Act would be better suited for trial before military courts rather than civil courts. I would, however, abide the exemption posited in Oxford Dictionary of Law that, and I quote, when a member of the armed forces is charged with conduct committed that is an offense under both service law and the ordinary criminal law, the trial must, in certain serious cases, e.g. treason, murder, manslaughter, and rape, be held by the ordinary criminal courts and is in fact usually held by them in other cases. Close quotes. I would construe this position to draw a distinction between the pure commission by a military person of a service offense on the one hand and a service offense that is also available as a civil offense. In addition, though seemingly restricted to capital offenses, I would extend it to non-capital offenses that accrue as both service offenses and civil offenses. In my view, therefore, the general rule ought to be that military service offenses are only triable in military courts and civil offenses are only triable in civil courts, save for two exceptions. the trial by field courts-martial of military persons that commit civil offences during field operations, and the trial of service offences by civil courts, where such offences do also exist on the ordinary criminal law statute books. I would therefore uphold the majority in the Constitutional Court that civilians that aid and abet military persons in the commission of a service offence do by their actions subject themselves to military law under Section 117(1)(g) of the Act. Section 1171H, on the other hand, subjects to military law any person found in unlawful possession of arms, ammunition, equipment, ordinarily being the monopoly of the defense forces or other classified stores. I find no definition in the Act as would guide a reasonable member of the public as to what type of military equipment is the monopoly of the UPDF, let alone what would amount to classified stores, so as to avoid the prohibited conduct. Article 2812 of the Constitution considers a criminal offence that is not adequately defined to undermine the right to a fair trial, and thus prohibits convictions arising from vague and ambiguous criminal offences. The need for a precise definition of an offence is associated with a principle of legality that translates into the constitutional principle of void for vagueness. The void for vagueness doctrine essentially requires that a penal statute define the criminal offence with sufficient definiteness that ordinary people can understand what conduct is prohibited, and in a manner that does not encourage arbitrary and discriminatory enforcement. Thus, legislative provisions that have not been defined with sufficient conciseness have invariably been adjudged to be void on account of their vagueness. On that premise, therefore, I am unable to endorse the constitutionality of Section 117(1)(h) of the Constitution. In the result, I find that service offences as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the legislative mandate of Parliament or the objective of the UPDF under Article 210A of the Constitution.